Good morning, everyone. Tanya Bartolini here with you. I'm a business and real estate attorney in Fort Lauderdale, Florida. Today I have a special guest, Marty Elberg, who is a probate attorney and who's going to talk to us a little bit about how to avoid probate for homeowners. Everybody knows the state of affairs that we're in, and even though it's always good to be prepared, this is a time that we need to especially be vigilant about being prepared and being able to properly save our assets and make sure that we can avoid costly litigation and court events. Marty, can you please just give a little bit of an introduction about yourself?
Sure. Thank you. Yeah, Marty Elberg, Circle of Life Legal Services. I'm an estate planning and probate attorney. The estate planning is to avoid probate. Probate is not something you really want to enter into because it's a lawsuit against a person's estate when they pass away. And we have to go through the court process, and I find that it is very disheartening for people when they find out that they have to do that. So that's why the planning is so important.
Thank you. So, a few housekeeping things. First of all, this does not create an attorney-client relationship. This webinar is not confidential. The information that we will be giving today should not be construed as legal advice. This is general information, and everybody's case is different. So your particular circumstances will dictate the best way for you to avoid probate as a homeowner. Also, this is being recorded and will be shared. If you have any questions, please feel free to go to the Q&A on your taskbar. You can enter any questions that you have. I will be monitoring that, and as we're going through the presentation, we will answer those questions or wait until the end depending on the question and where we are in the presentation. So without further ado, let's start. Go ahead, Marty.
All right. So we're going to talk about 5 ways for real estate owners to avoid probate. Like I said before, it's very important to look at the planning to avoid the probate, because the probate, while it might not affect you as the homeowner that's still alive, it will very much affect your loved ones that you're leaving behind. That's why I think planning is so very important. And just was researching some stats the other day. Less than 40% of people in the United States have a will.
Wow.
Much less a plan that will avoid probate. A lot of the reasons they do that is because they think it's too complicated. They can't find a good attorney. They think it's too expensive. They think it's too cheap. They don't want to do it online because it's just too complicated. I really do try to make things very simple. Not easy, but simple, because it is not an easy thing to do. I talk about death. We talk about being disabled. So we go through a whole lot of life stages that are possibilities that could happen. And it's just inevitable that we're going to die. And the more you look at that and realize that's gonna happen, we can actually make it a little bit lighter. We can, have a little fun with it, as much fun as possible, I guess, when we're talking about death. Some people are okay with it, some people aren't. But when we get into probate, that's when you leave your loved ones behind. And they're not only suffering because they've lost you, the loved one, they now have to hire an attorney and go to court in order to get the things that you've left behind for them. Okay, and I'm going to go through a few ways, 5 different ways that you can avoid probate with real estate. And these techniques also apply to a lot of other different accounts you may have, like bank accounts, brokerage accounts, and we'll discuss the pros and cons of each. All right, so we'll go to the first one, a gift before death. All right. So if you want to get rid of your assets and you want to make sure your loved ones have the assets before you die, the first thing you can do is you can just gift it to them. You can sign a deed that transfers immediate ownership to your loved ones. So like I say, it's immediate. One of the cons is you lose total control of it because you've gifted it to that person. That person now owns it. So you lose the ownership. And if that person that you gifted it to, it's not their homestead and they have a creditor issue where they've got credit card debt, maybe they're in a difficult marriage, maybe they have run into somebody, like a car accident, and they get sued, and now they have this house, and this house is there and it's an asset, and if it's not their homestead, there's no creditor protection on it. So the creditors can come and take that house. If you've got a mortgage on it, that may cause an issue because the person you're transferring it to may not be able to pay that mortgage. Or you can continue to pay the mortgage, but then the mortgage company says, well, there was a transfer in ownership, so we're calling the mortgage due right now. So a lot of issues you have to deal with if you're going to gift it before the death. And the last issue is there could be a tax issue, a gift tax issue. Now, I do not provide tax advice. So if there's a tax issue that you have, you really do want to contact your CPA or your accountant or whoever does your taxes to see how this would affect your taxes. All right. So that's gifting before death. That's something I do not generally recommend. Let's go to the next one.
As far as the mortgage, most people don't know that if you transfer ownership, most of the time that is an actual default on your mortgage, which is why Marty had said that they can call the full amount of the mortgage due. Another way you can probably try to do this is having a mortgage and note assumption with the person that you're gifting to, or as we move forward, you can see the other ways that do have a mortgage issue, but that also tends to be a little bit problematic, and you have to go through the mortgage company, maybe a refinance or something to that effect. So it does become very extensive.
Thank you. Perfect. All right. So the next way you can transfer ownership is through joint tenants. And the whole name of this is joint tenants with rights of survivorship. Some states even require saying, and not as tenants in common. I don't know if Florida is that strict on that, but I'm from Iowa, and Iowa was that strict on it. It had to say that whole thing. Joint tenants with rights of survivorship and not as tenants in common. The difference is joint tenants with rights of survivorship, when one person dies, it transfers automatically to the surviving owner. So that's how you avoid probate with joint tenancy. If it was a tenants in common situation and one of the owners died and that person didn't have any other estate plan put in place, that would have to go through probate. Now, if that person is not, if the other owner is not a legal heir to the person that died, this person's going to have ownership with this person's legal heirs, which could be his wife, his kids, his parents, whoever happened to be the legal heirs if you didn't have an estate plan put in place. So it does cause probate if you have a tenancy in common. Now this happened, and this is one of the reasons I preach about this so much, is because a past client of mine that I had to do a probate for, they had an attorney friend, and there are all kinds of different attorneys. So just because you're an attorney or you have an attorney friend does not mean they know exactly what they need to do. So unfortunately, this attorney friend created a deed from the father because the father had the house and he knew he wasn't in great health, and he wanted to transfer it to his daughter because his daughter was actually living in the house. So he bought it for her, but it was in his name. and his health deteriorated. So they asked an attorney friend to draft a deed to transfer it to both of them. So that's exactly what the attorney did. He transferred it to both of them, but he did not use the magic words as joint tenants with rights of survivorship. He deeded it to them as dad and daughter, no other language, which means the default is tenants in common. So he died. We had to do probate on his half of the ownership of the house. It took over a year and a half to do because the court system was a little difficult. All of his heirs, his legal heir, actually half of his legal heirs were in a different country. Half of them were here. He had 5 kids, one from a different marriage, and she had to negotiate with every one of those kids ownership of the property that she had been paying the mortgage on, that she had been living in, that she had been doing the upkeep on. And all of her siblings luckily signed quitclaim deeds to her, relinquishing their ownership of their half of the property. Took a long time, a lot of negotiation, a lot of sucking up, for lack of any better legal term. But that's not going to be the case in a lot of family situations. And I've actually seen it the other way around, where people are like, no, I want my money. Pay me for my half. And I've seen it way too many times. So it's so very important to understand what you have. So if you don't go away with anything, go look and see what your deed is if you own it with somebody other than your spouse.
Yeah, you don't want to get stuck with owning a 50% of a house.
Exactly.
Having
especially if you bought it together, right? And when you're naming somebody as a joint tenant, you're probably going to have more of a plan, maybe not, it doesn't matter. But as joint tenants with rights survivorship, the survivor gets everything. So just as long as those magic words appear on the deed, you're fine, okay? But if you're trying to get rid of the property for planning purposes, this is one way to do it. It is immediate. You do lose some control because now you've added another owner. So if you decide you want to sell that house down the road, the person that you transferred half of the home to has to sign off on all that. So you lose partial ownership. You've got a creditor risk. So the person that you transferred the house to, if they have any creditor issues, same as before, those creditor issues could attach to that house if it's not your homestead. But if it's your homestead, now you've transferred it, half of it, to somebody that doesn't live there. It's not their homestead. Now you have a whole nother issue with your homestead protection and your homestead taxes and everything that has to do with all the wonderful things that Florida's given us with homestead protection. So not the best way to do it, especially if it's your homestead. You've got that creditor risk. You've got another mortgage issue that we've already talked about. And one of the worst issues you could have is there's no step up in cost basis. So let's say you bought the house at $100,000. 10 years later, you decide you want to give the house to your daughter when you die. So you're going to just add her to the deed as joint tenants with rights survivorship. So you did it right that way. And now 10 years later, that house is worth $200,000. You don't die for another 10 years. So now the house is worth $400,000. You die, you leave, the house automatically transfers to the daughter. Great job there. We avoided probate. Now she has the house. That's a $400,000 house. She wants to sell it. And her cost basis is yours, $100,000. That means she's going to have to pay taxes, capital gains taxes, from 100 to 400, the sales price of that house. That's a whole lot more than it's going to cost to put a great estate plan together. So not a good way to transfer a low valued asset when you initially bought it. So cost basis is one of the biggest disadvantages to this technique. And there could also be a gift tax issue. Anything to add on that one?
No, you're correct. They can talk to a tax attorney or a CPA and try to figure out how to maybe lower the tax liability. But like you said, it costs a lot more than to just have a good estate plan in place from the beginning.
Thanks. All right, the next technique to avoid probate for homeowners is to grant a life estate. All right, this is a little bit more abstract if you don't understand real estate, but that's why we're here with Tanya. So she can fill you in on the little details here. So life estate means the person that owns the house, that's this person over here, grants an interest to the person that they want to have the house. They then, the homeowner, keeps what's called a life estate, which means it's only good for their life. That means they get full possession of the house, they have full control of the house, not quite full control, I'll get into that in a second. But they get to live in the house, they get to do what they need to in the house. This person just hangs out, they wait around. They have no ownership of that house until this person dies. If this person dies, this person now gets the house. Now, where you can lose control is if you don't do what we call a ladybird deed or an enhanced life estate, which retains all of the grantors or the person that owns the house's rights to sell the property, lease the property, do whatever they want to the property. So if that's not included in that deed, it's like the magic words I talked about with joint tenants with rights to survivorship. If those magic words are not in that deed, the person holding the life estate loses a lot of control. Okay, so that means they may not be able to refinance without this person over here is called a remainderman. So the remainderman has to join in whatever the person holding the life estate wants to do. So that control issue could cause a lot of issues. Okay, there could be a creditor risk, not necessarily for the life estate holder, but for the remainderman. If the remainderman has creditor issues and that house transfers automatically to that person and it's not their homestead, their creditors can attach that house and take it. Do whatever they need to. They can foreclose on it. They can basically get the house or whatever ownership that they can get based on what that person owes. Okay? Big deal with the creditor issues there. Like I said, the remainder has no rights to the property until the life estate owner dies. There could be an issue with mortgages, but I don't think it hasn't come up a whole lot with mortgages because that life estate owner is still responsible for all the expenses.
One of the things that I have seen that was a problem with a life estate is that the person, the grantor, sold the property and someone else was living in it. When the grantor died, remainderman now has title to the property because it doesn't matter who's in it. The life estate gave the remainderman rights to the property once the grantor died. And that caused a whole lot of issues, including fraud and different things. So you have to be very, very careful.
And hopefully the purchaser had great title insurance.
Yeah, that's what it's there for.
Right, exactly. All right, so that was, so the first three were fairly easy solutions to avoiding probate. Not the best solutions to avoiding probate, but the easiest. And those are some of the things I see when I actually have to do probate because they try to do those things and they don't do them correctly. Or they leave something out, or it's just not quite right. And then there are other implications, like I said, the step up in basis, the ownership, the not leaving rights to the house. So not the best solutions. All right, now we're going to get into some estate planning, true estate planning, ways to avoid probate. All right, the first one we're going to talk about is irrevocable trusts. This is where the grantor, remember the person that owns the house, puts the house into a trust. Now, this particular trust I'm talking about right now is an irrevocable trust, which means it cannot be changed because that's the way they set it up. Why they do that is if this person has this asset, they put it into the trust. The trust now owns the property. It is now out of the grantor's, we're going to call this person a grantor, out of his assets and into the trust. He still may have the benefit of using that house, but he doesn't own it anymore. The trust owns it. He has to give up control because he has to name a trustee that is not a beneficiary. It's going to be unrelated, not necessarily unrelated, but with no interest in this house. And this trustee now manages this asset, pays the mortgage, makes sure it's kept up. And yeah, the grantor may give guidance to the trustee in certain situations, but the trustee does not have to follow the guidance from the grantor. So you lose control, you lose ownership because it's now over here. Creditor risks are now controlled for the grantor as long as there were no creditor issues before the transfer to the trust. That's important. Before the transfer to the trust, we're okay. Or if there were, sorry, let me clarify that because I think I backwards it. So if the grantor owns the house without transferring it into the trust yet and has no creditor issues yet, that transfer is okay. Back over here, the grantor has creditor issues. In other words, he's got credit card debt, he's got a lawsuit pending against him, anything like that, and he transfers it over here. You do not have necessarily creditor protection against those pre-existing conditions, we'll call them, into the trust, all right? So those are some of the issues with that, with creating an irrevocable trust. And the reason I have the money bag there and the coffee shop there is because you can transfer anything you want into the trust, and then the trust would control it. Now, irrevocable trusts are not being used as much as they had been in the past because the estate tax is so high now, or the exemption on estate tax is so high. It's almost 12 million per person. So 24 million for a married couple, almost, not quite. It's like 11.9 something. And it keeps going up every year. So as long as that's up there, that's less than 0.5% of the population. I think it's closer to about 0.2% of the population, 0.3% of the population. So it's not as prevalent. Back when it was 600,000, that's where we saw a lot of irrevocable trust being put in place. And it's got to be put in place at a younger age because there is a look back period. So something to think about, but not usually the best choice. It does create an easy transfer of the property when the grantor dies. So that's good. It does avoid probate. That's good. But a lot of people don't want to give up all that control. Okay.
And so if you have creditors prior to getting the irrevocable trust, you could be liable for what's called fraudulent transfers, and a judge could actually undo your whole irrevocable trust to pay off those creditors. So that becomes a lot more expensive. So as Marty said, you have to make sure that you don't have any creditors or creditor issues prior to doing that.
All right, and the final one that we're going to talk about today, there are a lot more, but I just chose the top 5, is one of my favorite, and that's a revocable trust. You may have heard of it as a living trust or a revocable living trust, but simplicity, we just say revocable trust. And this is where you do transfer. So we still have that grantor. A grantor transfers the asset into the trust, and we're talking about real estate right now. So transfer it into the trust. And because it's a revocable trust, which means that grantor can change it at any time, do whatever he wants to it, change the beneficiaries, change how it's set up, change who gets what, change what's in it, or just totally get rid of it. You can just say, I'm done. I don't want this trust involved alive anymore. So we can just totally revoke it. Thus, revocable trust. Okay, so it immediately transfers the assets into the trust through a deed. So if we were talking about real estate, we would do, and I learned this from a real estate attorney, which is why it's important to have relationships with other types of attorneys, is to transfer it with a warranty deed, not a quitclaim deed. I've heard a quitclaim deed cuts off the title insurance, but a warranty deed will maintain that title insurance. Is that correct?
Yes, that's why it's a warranty. So there's a warranty on the deed.
All right, so there you go. There's our crossover tips there. So it is immediate once that deed is recorded, and you have the grantor maintains total control. That means they get to live in the house, they get to sell the house, they get to remortgage the house, they get to pay off the mortgage, they get to fix it up, they get to tear it down. They can do whatever they want to that house. They lose no control. They have total ownership of that because they haven't given up any ownership. They are the grantor, which is the person that puts the asset into the trust. They're also what's known as the trustee. That's the person that manages all these assets that you see in the trust. And they're also the beneficiary of that trust. So they own it, they manage it, and they're beneficiary of it. That's how it works. Once that person dies, then the other people that they've named as the beneficiary will get that house, and they get it through the trust, not through the court process probate. So it avoids probate. It's one of the easiest ways to avoid probate and maintain control, maintain all ownership, not have any issues with your mortgages. Most of them have a clause that says there is no due on clause, does not kick in as long as you maintain all of your control and beneficial interest. And this accomplishes that because they understand that a lot of people are moving things into the trust. I do recommend that you notify your mortgage company. You did do that just so they have that information. You also want to check with your insurance company to make sure it's an additional insured. So you're covered on all those bases, but it's a fairly easy way simple way to transfer assets. I don't recommend you going out and doing it on your own. Please do hire an attorney to review what you have, or if you do go out and do it online, have an attorney review it because like I said, getting things done online it's convenient, it's fast, it's easy, it's usually cheap, but sometimes being cheap in the beginning ends up being very expensive in the end. And that's what we want to avoid with proper estate planning. So, and you also get that step up in basis, or your beneficiary gets that step up in cost basis. Remember we talked about that, buy it at 100, you die and it's worth 400. They then own it at 400. So if they turn around and sell it right after they buy it, they don't have a capital gain. Whereas the other joint tenancy, the joint tenancy example I gave, they own it at 100, sell it at 400, they've got a capital gains tax. Again, talk to your CPA about that. That's the basic rule for step up in cost basis. All right. Also, this tool, having a revocable trust, you can put your other accounts in it. You can put the ownership of your business in it. You can do a lot of things with this revocable trust that'll avoid probate on almost all of your assets. Well, really all of your assets. And then we've got other things to do to avoid probate with some other things. And be more than happy to discuss that with you. If you want to set up a free consultation, I'm available. I'm sorry, I got off track there. So this is also a great tool for what we call incapacitation. So, Florida's got an aging society, and we've got some people with some Alzheimer's issues, with some dementia issues, or just physical ailments where they're not able to physically get out and manage properties or manage whatever assets they have. So a successor trustee can be appointed by the grantor, the person that started this. So the people we're talking to, start your trust, you are the initial trustee, but you can name somebody to take over if you cannot do this. So that means it doesn't just take effect when you die, it takes effect whenever you want somebody else to take over. If you decide you just want to retire and you have 4 or 5 other properties that you've been managing and you want to turn that responsibility over to your successor trustee, you can do that. You can resign as trustee, appoint your successor trustee, and they can take it over for you. Go have a nice vacation. If you're incapacitated, that successor trustee can come in and make sure all of your assets are taken care of for your benefit. And it's got to be for your benefit. They don't have to preserve assets for the beneficiaries that you've named. For your benefit first. Secondary beneficiaries are once you pass away. Those beneficiaries then would get whatever's left. So great tool. The tool I recommend most to homeowners, to people with other assets that they want to transfer, especially when we're dealing with minor children. Okay, so if you've got kids that are under 18, actually under 21, because there's this thing called the Uniform Gifts to Minors Act, where kids under 21 can't get more than $15,000. Why they haven't changed that age, I don't know. So let's just say you have a house and you have a husband and you have a couple minor kids and you die. It goes to your husband, and there are some other issues with the homestead, but we'll just keep it simple. It goes to the husband. Husband, let's just say husband dies at the same time. Unfortunate circumstances, they do happen, and that's why we plan. We plan for all things that nobody wants to think about. So let's say both die at the same time. Now that house or those assets are left to those kids. Those kids are minors. They can't own assets because they're minors. So now somebody has to step in, say, I'll take care of the kids if you've not appointed somebody to take care of the kids. And then the court says, okay, great, you're going to take care of the kids. You also are going to take care of the assets, or somebody else has to step in and do that. So now they've got a guardianship over the kids. They've got a guardianship over the assets. And they have to go back every year to court to show what's happened with these assets. Every year, over and over. There's constant court supervision, which can be good, but it can also be a pain and a financial strain. It costs a lot of money. And you could have 2 competing interests. Maybe dad's family thinks they're better to take care of the kids than mom's family. And then they fight in court, and then the kids, well, the court doesn't know what to do with them, so they put them with Aunt Sally, who maybe Aunt Sally's not the best choice. Maybe it was Uncle Jim. So it causes so many issues not having a proper plan. And that's why we can solve all those issues with proper planning. Now I kind of went a little bit further than the revocable trust here, but it really has to do with transferring your assets without a need for probate. With the revocable trust, the asset remains inside the trust until those kids reach whatever age you say they need to be. They can be 25, they can get a third of it. They can be 30 and they can get another third. They can be 35 and then they get the rest of it. So you get a setup when your kids or your beneficiaries get these assets. So that's the way we avoid going to court every week. I know I kind of went the full way around, but it's so very important. And guardianship is also part of the probate court. So it really does fit in with how to avoid probate in all different ways. It's a great tool. All right, so we'll just kind of round it out with, remember that the only guarantees in life are taxes and death. And I've heard some people get around that tax issue too, but I've never heard of anybody escaping death. So the more we prepare for both, the less expensive it will be for you and those that you leave behind. So make a plan for your family's well-being.
And as the saying goes, failing to plan is planning to fail. And that's true for every aspect of your life. Even though you might think, oh, it's too expensive to have an estate plan right now, or it's too expensive to have a business plan right now, or whatever the case might be, you have to put in perspective how much it's going to cost later if you don't do those things now. Because the cost of doing something now and planning is going to be maybe 10% of what it's going to cost you if you don't plan later on to fix everything. And the time that it takes to go to court, all of the fighting, all of the families, people come out of the woodworks and say they have claims to things. And those are things that you want to avoid. Those are things that you want your family to avoid. And you don't want to spend your estate on attorney's fees. As much as we like to take your money, we'd rather not. You know?
Exactly. Yeah. I'd rather take your money for planning
yes.
than the money that your kids need because you left it to them. And that 6 to 18 months of just not knowing what's going on because the court process just takes a while.
Yes. So make sure that what you want to happen does happen by having an estate plan. I believe we have a question. Hi, Tanya and Marty. Great information. Thank you both for your time. My question is that I loaned my brother some money to buy his homesteaded condo. His wife is aware of it, but to make sure that the loan is repaid in the future and to avoid any problems with his wife, he would like to transfer his share to me. They don't have kids. What is the best way to resolve this issue? Unfortunately, we only did a promissory note without any lien note put in the property. It was done mainly on a trust issue between us. Oof, I see a lot of potential legal issues in here. Do you have a simple answer, Marty, by any chance?
Because it's homestead. Yeah, the simple answer is if he wants to transfer ownership of the homestead to you, and this is probably a crossover question, and a divorce question, a family law question. I've retired from family law, so good thing I understand a bit about that. Retired, I guess. So because it's homestead, if he does want to transfer the ownership of the condo back to you, then his wife needs to sign off on that as well, because it is the homestead. It doesn't matter if her name's on the deed or not. She still has to sign off her homestead rights to that house or condo, whatever the real estate it is. Okay, that's the simplest answer I can give you.
Yep. So any other questions? Going once, twice. Oh, here we go. Another question. If someone has bought a property before marriage in the state of Florida, does the legal partner own half of it even though they didn't buy it together? This property is not homestead.
Short answer. Oh, go ahead.
Yeah, I was just going to say, and I think Marty will agree, the short answer is no, because it is not marital assets and it is not homestead. Is that your understanding as well?
Yep, my understanding as well. Now they're and then I'll throw in the family law issue. Okay, years later down the road, they decide to get divorced. The other person, the other spouse that's not on the ownership can claim marital assets went into the upkeep or paying the principal of the mortgage down or paying any of the expenses for that house, and could, not always going to happen, but could receive some kind of offset payment for any of the marital assets, marital money that went into there. So it's really good idea to have an estate plan set up or some kind of plan set up for that house to maintain its own expenses throughout the life of the marriage, throughout the life of that house. So if it's a rental, make sure there's an account for that house, and that account always pays for this house. Don't ever put the marital money over here. Keep it totally separate.
So as I had stated in the beginning, each situation is different, and that's why every situation has to be looked at in its totality. So this advice is not to be construed as the legal advice for these answers. This is just general information. please understand we don't have any of the documents, so we don't know how the deed is worded. We don't know, you know, where the money is coming from to maintain it, as Marty said. So these are just general. If you have, if you want specific answers to your questions, Marty's information is on the slide. My information is on the slide. We are both happy to discuss real estate and probate avoidance and estate planning with you. Obviously, I'm only the real estate part. Marty will do the estate planning, wills, and probate. So,
Right on. Hi.
There we go. So since we have no more questions, thank you so much, Marty, for joining me today. Oh, wait. Thank you both very much.
So one other thing, I know it doesn't have anything to do with real estate, but I do offer a free healthcare surrogate, or a healthcare directive, which includes naming a healthcare surrogate and the living will. So if anybody is interested in having one of those, just email me at marty@circleoflifelegal.com, and I will send you the information for the healthcare directive.
Thank you, Marty. It was a pleasure having you. Thank you, everybody, for listening to us, and I hope you took some value out of this. And I just want to say, have a great day, everyone.
Thank you.